The Institute
for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined today by Clark Neely and Evan Bernick of the Institute for Justice's Center for Judicial Engagement. If you enjoy the podcast, be sure to subscribe to the email newsletter, which is also called Short Circuit. To sign up, go to ij.org/shortcircuit. This week on the show, a misbehaving automotive company, your constitutional right to weeds, and a fishy fishing case from California. First off, troubling misconduct at Goodyear Tire. Clark.
Well, this is a product liability case basically involving Goodyear tires and sort of a lesson in how not to litigate. If you represent a big company and there's a bunch of really, really incriminating tests that you've done on, let's say, a popular model of tire that is involved in a lot of very serious fatal rollover accidents, you have essentially three choices. You can do what professional ethics requires, which is to produce the tests when you are asked for them. Another option is to try to destroy all the tests and pretend like they don't exist. Or you can do the third option, which is what the attorneys in this case did, which is to essentially force the other side to ask you in the most specific possible terms for each and every test and just dole them out in dribs and drabs and try to prolong it as long as you can, basically in an attempt to manipulate the other side into a bargain settlement. And that is exactly what happened in this case. The problem is that sometime after the case settled, the plaintiff's attorney, who had been in some sense, the victim of this hoodwinking by the defense lawyers, realized, because of something he read about another tire case, that in fact they had a bunch of tests they never disclosed. He brought that to the attention of the court, and hilarity ensued.
Yeah, so this company essentially kept information about tests that were conducted on these tires from people who were suing them for an extended period of time, represented to the court that they were turning over all relevant documents, and eventually secured a settlement from the plaintiffs on the basis of, they had turned over all the relevant information. They didn't have enough to go on, so they settled the case. Information comes to light afterwards. They didn't turn over everything that they need to, and the court imposes staggering and well-deserved sanctions on them for misleading the court for an extended period of time and manipulating these people into a settlement.
So nobody should ever engage in this kind of unethical behavior. But if you do, at least don't do it in a way that is as incompetent as these defense lawyers. One of the things they actually did in this case was, after representing to the district court that all of the relevant tests had been produced, they accidentally produced another test that they had never produced before in response to a court order. They just accidentally produced a test that they had misled the court into believing did not exist. Do you think the judge was pretty upset with him about that? He was. And how much was the amount of the sanctions that he imposed? $2.7 million in what the district court judge characterized as essentially attorney's fees that were imposed from the date of the first discovery response that failed to disclose the relevant materials. So essentially the judge said, from that date on, I'm going to make you, the misbehaving defense lawyers, pay all of the attorney's fees that were incurred by the plaintiff's lawyer, $2.7 million. The issue in the case was that an appropriate sanction for this conduct, and actually it did split the panel.
Yeah, so it split the panel. The panel majority comes to the conclusion that this is appropriate given this sustained period of bad faith and deception. The dissent comes to the conclusion that it's not appropriate, despite the fact that you could say that because these tests were kept from the plaintiffs, they might not have settled early. Well, Goodyear might have contested what those, the content of those tests. There might have been a back and forth. We can't be sure that they would have settled. But the panel majority wasn't having it, and they came down hard.
Evan, there's a good quote in this one that you wanted to read.
Yeah, there's really a stirring declaration from the district court, which is determined to send a message. Here's the quote: "Litigation is not a game. It is the time-honored method of seeking the truth, finding the truth, and doing justice. When a corporation and a council refuse to produce directly relevant information an opposing party is entitled to receive, they have abandoned these basic principles in favor of their own interests. The little voice in every attorney's conscience that murmurs turn over all material information was ignored." It warms one's heart a little bit to to hear the affirmation that attorneys have consciences and that they should be responsive to them.
And there's actually one more aspect, picking up on that quote, there is one more aspect to the case that's particularly interesting. Not only did the district court impose a monetary sanction in the form of the $2.7 million of attorney's fees, the court also instructed Goodyear and its attorneys that in all future product liability cases involving allegedly faulty tires, they actually have to file a disclosure in each of those court cases explaining what they did in this case and how they tried to hide discoverable material and, essentially pointing the finger at themselves as having behaved unethically in another tire case so that people can be on notice. That's pretty strong medicine, but if there were ever a case in which it was justifiable and richly deserved, this is it. Bottom line in this case, if you are a law student, you should read the case. You can find it in our Short Circuit newsletter. It's Hager versus Goodyear Tire and Rubber Company, and every single thing the defense lawyers did in this case, don't ever do if you want to be an ethical lawyer, and you should want to be an ethical lawyer.
Well, Clark, I certainly want to be an ethical podcast host. And with that, we'll move on to the next case, which comes out of the Ninth Circuit as well. Evan?
Yeah, so this case involves the Privileges and Immunities Clause, not to be confused with the Privileges or Immunities Clause, and it also involves commercial fishing licenses in the state of California. California charges non-resident commercial fishers 2 to 3 times as much for permission to fish in California. And the question is whether this violates the Privileges and Immunities Clauses bar against discrimination against non-residents. So Privileges and Immunities Clause says, to the extent that there's a common calling that people can engage in, there are a set of fundamental rights that people have, you can't discriminate against non-residents in restricting those rights.
Clark, what did the Ninth Circuit say?
Well, the Ninth Circuit didn't. This is not a slam dunk case. Basically, the issue in this case, as Evan mentions, is that California is charging non-resident commercial fishers a higher fee, essentially, to engage in that conduct. And this is something actually that comes up somewhat frequently. In fact, one of the most important Privileges and Immunities case from the Supreme Court is a 1948 case called Toomer, in which South Carolina was charging out-of-state or non-resident shrimpers, I believe it was, a higher fee to engage in shrimping in South Carolina waters. The reason it's not a slam dunk case, you might think, look, you can't discriminate against non-residents. The reason it's not a slam dunk case is that there is a principle that basically says, look, if residents are paying through some other tax that only residents pay, let's say like a property tax that only California residents pay, if the state is taking money out of that tax revenue and using it for conservation purposes, then it might be legitimate to charge non-residents a higher fee for fishing because they're not kicking in money through these other funds, in other words, through like local property taxes. And basically the dispute between the majority and the dissent in this case is whether that principle is involved here. In other words, whether California is plausibly charging non-resident commercial fishers a higher fee for coming to fish in California waters to make up for the fact that they're not kicking in through other taxes. And it's an interesting dispute and an interesting point. Everybody should pay their fair share, but the question here really is California trying to stick it to these non-residents? That's what the majority thinks is going on. The dissent begs to differ.
And how did the majority come to that conclusion, Evan?
Well, the majority concluded that California actually hadn't produced any evidence that the fee differential approximated the taxes that residents contribute to the state expenditures related to commercial fishing. So it's not a matter of paying their fair share. To the extent that disparate taxation could be justified in terms of, hey, you're fishing in our waters, you don't have to pay property taxes, et cetera, they haven't shown that the tax differential is proportionate to that.
Clark?
Well, there's an interesting takeaway from this case. Basically, whether the right to earn a living is a fundamental right depends on what context it comes up in. So here it's in the Privileges and Immunities context. That's a constitutional provision the Supreme Court still cares about. In other words, not allowing states to discriminate against non-residents. And so the Supreme Court has accurately characterized the right to earn a living in this context as fundamental. Of course, that goes right out the window when we move into the equal protection and due process area under the 14th Amendment. the Supreme Court turns on a dime and says, oh, no, actually, under the 14th Amendment, the right to earn a living is not fundamental. And instead of trying to figure out what's really going on, as the courts do in privileges and immunities cases under Article 4, courts should just rubber stamp whatever the government's doing and not make any effort to determine what's really going on. Because, again, the right to earn a living is either fundamental or non-fundamental, depending upon which provision of the Constitution it comes up under. As Justice Scalia might say, that's applesauce.
Okay, let's move on to the next case, which involves your constitutional right to weeds.
Yeah, so not the kind of weed you might think. This actually deals with an ordinance in Chicago that bans property owners from having weeds, plants, in their yard that grow more than 10 inches on average, and imposes fines of up to $1,200 a day if your weeds aren't properly trimmed. And the question is whether this is an excessive fine under the Eighth Amendment or it violates the First Amendment because weeds are a form of expression.
Yeah, there's another issue, too. There's a vagueness challenge here because of the way that a weed is defined. It's not really defined very precisely in the statute.
It's not defined at all in the statute. You have to look elsewhere.
You have to look to the regulations, and the regulations actually say that to determine whether your weeds are in violation, you have to take the average length of all your weeds. And Posner hypothesizes this scenario where you're literally the property owners out there measuring each and every weed, maybe up to 1,000 weeds, and then adding all of the lengths together and dividing by the total number of weeds to see if the average is over 10. The whole thing is kind of silly. This is Posner in sort of his classic form. This is one of the the rare judicial opinions that actually has pictures. He's got pages and pages of pictures of different plants to sort of illustrate another problem with the statute, which is that, what is a weed to you might just be a natural plant to somebody else and something they actually wanted to cultivate. And neither the statute nor the regulation is particularly clear on where the line is between a forbidden weed and an aesthetically appealing native plant. The whole thing is kind of funny and comical, but there is an underlying seriousness here, which is that in many towns and municipalities, these kinds of laws are used to harass homeowners. They have page after page after page of these picayune laws about you can't have weeds, you can't have bare patches, your fence has to look a certain way, you have to have curtains in your windows, and it just goes on and on. And unfortunately, this whole massive regulation contributes to the kind of situation we've seen in Ferguson, Missouri, and elsewhere, where local governments essentially use the ability to cite homeowners and other citizens with these obscure sort of quality of life ordinances as a kind of an alternative tax system, a very regressive alternative tax system where they're basically using their own citizens as walking ATMs just by citing them for all of these obscure violations. That's not particularly what's going on in this case. It's a commercial property. These people should have no problem complying, but it's important to remember how these ordinances can be used against individuals, and they can really be abused.
Posner's a little bit dismissive about whether the fines in this case are excessive. Can you tell us more about that, Evan?
Yeah, Posner, in analyzing this case, he's realistic about the fact that these determinations of what is a weed, what isn't a weed, aren't really there's not a statutory definition. You have to kind of look through the ordinances to figure out what's going on, and that a lot of this is going to end up depending upon ad hoc decision making by city officials. And these fines, $600 to $1,200 a day, that's a lot of money. Posner's pretty dismissive of the possibility that this raises a constitutional problem, either in terms of fair notice or in terms of excessive fines, but I think that there is a serious issue here. I think one of the main problems with this case is the choice of plaintiff. The people who are bringing this suit discount in. Posner actually has to go on the internet to even find out who and where these people are, and their claims are impeded by the fact that their identity is hard to determine and the arguments that they're making aren't particularly strong. But I think that an effective challenge could be mounted in a different context under a different set of facts.
Yeah, and more precisely what Posner's getting at, this is right in the beginning of the opinion where Posner kind of complains that the court has not given much information about the plaintiff. And specifically what's going on here is There's no indication, apparently, in the briefing of where the properties in question are located. The company that owns this discount inn is in Skokie, which is not Chicago, and the issue here is Chicago issuing the citation for weeds. And so Posner is kind of grumbling about the fact that the court has not given much information about, the parties and specifically where the property in question, in other words, the property that was cited for the weed violation, is actually located. It's important to understand what's going on behind this, sort of underneath the subtext here, and that is that when cases come up to courts of appeals, one of the first things they do is look to see if there's some way to throw the case out on a technicality, and that would involve things like ripeness, standing, jurisdictional issues, and there are some judges who are very above board about this. They literally put their clerks to work looking to see if there's some way to throw the case out on one of those avoidance doctrines. And it almost sounds as if Posner is complaining here because they were sort of deprived of the ability to know for sure whether there's some way to throw this case out on a procedural issue as opposed to having to get to the merits. And he's essentially telling lawyers, look, in the future, you need to tell us more about who you are and what your case is about. And he doesn't say this, but pretty much so we can determine if there is some procedural defect that we can use to avoid the merits.
Okay, that concludes our show. Thanks for tuning in. For more judicial engagement, be sure to follow Clark and Evan on Twitter. Their handles are @ConLawWarrior and @EvanBurnick. And again, you can subscribe to the Short Circuit email newsletter at ij.org/shortcircuit. Until next time, this is John Ross from the Institute for Justice, cajoling you to get engaged.